Thank you. Today is Thursday, October 12th. It is now 3 p.m. We public meeting. The public meeting held under Section 34 of the Planning Act is declared open. The applications on public meeting agenda today are for the public consultation purposes only and will be addressed by future council meetings. At this time, I would ask staff please to confirm that required notices were given and subject applications in accordance with the requirements of the Planning Act.
Yes, thank you. Through the chair, the required notice was given. Thank you.
Thank you. All those present at the public meeting today will have the opportunity to speak in favor or in opposition of the applications. Any or all comments and information submitted, whether orally or in writing, including identifying information, becomes part of public record and could be made public available at any point in time, including on the town's website or other electronic formats or publications in accordance with the Planning Act requirements. Any person wishing to receive notice of decision regarding the applications being considered must send an email request to the Township office immediately following this meeting. In all cases, must be received prior to the date of the decision of the Township Council on this matter. Pursuant to the provisions of the Planning Act, the rights and limitations of appeal under the Ontario Land Tribunal with respect to the decision of the Council on applications are as follows. A person or public may file an appeal with the Ontario Land Tribunal within 20 days of the issuance of notice of decision. The person or public body must submit the required form of appeal to the Township, which shall include the required information and explanation of the reason for the objection to the decision. In addition, to pay the required fees set out under the Ontario Land Tribunal Act. If a person or public body does not make oral submission at the public meeting or make written submission to the town in respect to the applications before the approval authority passes or refuses to pass the proposed amendments, the person or public body may not be added as a party to the hearing of appeal before the Ontario Land Tribunal, unless, in the opinion of the tribunal, there are reasonable grounds to do so. At this time, I'd also ask if anybody has any cell phones, just to make sure they're on mute or vibrate, please. Thank you. At this time, I'll ask staff to please describe the purpose and effect proposed zoning bylaw amendment related to file number ZB 2306.3, submitted by Jim Hewer and Karen Kaleo. Is that the correct pronunciation? Close enough? Okay. And if it's not, I apologize if you're listening. And summarize any written comments received. Planner, please advise.
Thank you. So this application pertains to lands known municipally as 1062 Lower Spruce Hedge Road, which is located in Part Lot 17, Concession 3, and is part of Part 1 of Registered Plan 17651 in the geographic township of Bagot. The subject lands are presently just over 16 acres with over 200 meters of frontage on the Madawaska River. The lands presently have an 875 square foot family detached dwelling constructed in approximately 2015. The purpose and effect of the amendment is to rezone the lands from rural to rural exception 52 to permit a secondary dwelling unit on a waterfront property, and for the secondary dwelling unit to be larger than that of the first dwelling. The present dwelling on the lands is about 875 square feet, so the new dwelling is expected to be just over 2,000 at 2,240. All setbacks have been maintained, including the required 30-meter setback. A hydrogeological report was submitted that demonstrates there's adequate water supply, quantity, and quality to support both dwellings, and it's not anticipated to have any negative impacts on the body of water, as demonstrated through the nitrate impact assessment calculations, which demonstrates that the concentration of nitrate at the down gradient property boundary will meet the provincial requirements for nitrate dilution. A scoped archaeological assessment was also undertaken and submitted with the application, which found no evidence of archaeological resources within the designated development area. I will note the applicants were not able to be present today for the public meeting, and also no written comments have been received as of today. And that's it. Thank you.
Thank you. It's usually at this point if we ask if the applicants have anything to say, but they're unable to be here today. Does anyone wish to speak in favor of this amendment? None seen. Does anyone wish to speak in opposition of the amendment? None seen. Are there any questions from members of council? Councillor Thompson?
I just have one. It's more of something to clarify in my own head. Does everything like this need an archaeological assessment?
Just the official plan requires that secondary dwelling units at front on a waterfront properties require a hydrogeological study to be submitted.
Thank you.
Thank you. Is there any other questions, comments, concerns from council at this time? There's none seen. Thank you. We'll move on to number 11. At this time, I'll ask staff to please describe the purpose and effect of proposed zoning bylaw amendment related to file number ZB 2206.3 submitted by Kelly and Jody Church, and summarize any written comments received, please. Thank you.
Thank you. So this application is regards to the lands known as 866A Taddy Hill Road. It's also, we're still kind of clarifying the civic addresses. So it's also known as 150B Adam Ben Lane, located in part lot 13 and 14, concession 1 in the geographic township of Blythefield. The lands are presently 10.37 acres in area, with almost the entirety of the land surrounded by Calabogie Lake. There's presently a single-family detached dwelling, detached garage, and a double-axle trailer located on the lands. I will note that the double-axle trailer is considered a legal non-conforming use. So the purpose and effect of the amendment is to rezone the lands from limited service residential exception 61 temporary, which is to permit a garden suite as a temporary use on the lands. The Planning Act defines a garden suite as a one-unit detached residential structure containing bathroom and kitchen facilities that is ancillary to an existing residential structure and that is designed to be portable. Additionally, the proposed garden suite will have a reduced water setback from 30 meters to 7.8 meters from the high water mark of Calabogie Lake. The temporary use bylaw would have a duration of 3 years from the date of passing of the bylaw, which I think actually is going to change to the execution of the development agreement, which will be a condition. Upon expiration of the 3-year period, council may by bylaw further grant periods of not more than 3 years each, during which temporary use may continue to be authorized and must be supported by a geotechnical report. At such a time when the garden suite is no longer required or the temporary use bylaw expires and is not extended, the garden suite is to then be removed from the subject lands. We did receive one comment from the Ontario Power Generation, where they advised that they didn't have any objection to the proposed zoning amendment, but provided that the following comments be considered, and that their comment is that OPG maintains an easement to a flood up to elevation 505 feet, which is 153.93 meters, over the lot areas in which the subject lands are located as described in instrument number BLY 353E. Essentially speaking, the subject property would not be flooded based on the actual land terrain of the subject lands. And that's all I have for now. Thank you.
Thank you. Does the applicant or their representative wish to speak in regards to this application? I see Mr. Church and his son Adam here today.
There was one
If you could just go up and use the mic, please, just introduce yourself. And guys, we just need you to talk up on the mic so we can be on record, please.
My son did all the research on it.
Just hit it.
My son did all the research on it. I'm just the owner of the property.
Is-
One thing that I did.
Is it green on your?
There
we
now
go.
we're okay. Again, I own the property and it's for my son. Obviously, through the pandemic, it's been pretty rough for trying to find housing and that. So this is what we're trying to do, is just have a place to stay until we can build a more affordable home. But the only thing I was wondering about, Adam, was in the engineer's report, in order to put it there, they asked for a stability test. And I think it says on there 7, but it's not 7, right? No, it's 4.2 or something. 4.2, which is on the engineer's report. So I'm wondering how that 7 came to be. Does that make sense,
I believe that was set back from the high water mark.
Yeah.
Yeah, it was like 4 is 3.8, one engineer report, and the other, I had 2 reports. One said 3.8, one said 4.2.
Right. So now it all,
I seen a new picture too, it's in the wrong area where the house is supposed to be too.
Yeah.
In that map, compared to the one that's at our house.
Adam, I'll need you just to be up close to the mic so we can get it on.
yeah,
In both reports, it said, I think one report says 3.8 from the high water mark, that's where that place had to be, and the other report was 4.2. So I don't know where 7.8 came from. It said that all in the reports too. But in the email I just got, I think it was 2 days ago, about today, it was showing the property, like where the house is gonna be at a different spot compared to like the first, like the original emails, like that is the permit that's on our property, it shows it at a different spot. So I don't know if something got confused.
yeah, it's to the right.
Because original email was all, I think it was 4.2 meters. And then now I seen the original, what I just seen in the email, it said 7 point something.
So I wanted to clarify that because,
Yeah.
Yeah, sure. I'd be glad to, and through the chair. Thank you. So the 7.8 meter setback, as the chair noted, that's from the high water mark. The setbacks that you're referring to in one case, in the case of the environmental impact statement, that setback is from the high water mark. Okay, so it's closer than the 7.8 that's shown on the site plan. The geotechnical investigation setback is from the stable top of bank. So that's been identified by the geotechnical engineer as being generally the location of the large stones that are on the property. So what this 7.8 meters is because it's difficult to map the location of those stones on the zoning. We asked the consultants that undertook the environmental impact study if they could then take essentially the inferred distance from the high water mark to the recommended setback from from the stable top of bank and give us what that would be so that we could implement it for zoning purposes. And that'll all be implemented together with the development agreement. Thank you.
Is there any other further comments either of you would like to make today? No? Okay. Does anybody else wish to speak in favor of the amendment? There's none seen. Does anyone wish to speak in opposition of the amendment? None seen. Are there any questions from members of council? Councillor Levesque.
Thanks for coming and sharing your requirement. 2 questions. I'm not sure if they're for you, Kristen, or not, but just a question on when does a trailer, because I have seen it and there's wheels on it, so in effect, somebody would call it a trailer. When does a trailer become a garden suite? Is it size? Is it the type of structure, the size of the structure? Like,
it's the type. Garden suite is like a step from a trailer to, garden suite is basically a big step towards going towards a house. A lot of times people put a garden suite in or a large trailer as they build their home.
so there are mobile homes, there are park model homes,
right.
there are trailers, and now the garden suite, which I'd never heard of a garden suite referred to as a trailer, but.
It's based on size.
Okay. Second question. So the maximum, according to what I'm reading here, is two extensions, if you will, so a total of 6 years until the structure has to be removed. Is that correct?
I think it's up to council.
Yeah, no, I understand, but if it passes now, it's for 3 years, and if it passes again at the end of the expiration, it's for another 3 years, and the maximum is 6. Is that correct?
Yeah, so 39 sub 4 of the Planning Act provides that despite the expiry date, council may by bylaw grant further periods of not more than 3 years each during which the temporary use is authorized. And it doesn't appear to provide an upper limit to that outside of, it's a 20-year maximum for garden suites.
Okay, thank you. And where is the ancillary existing residential structure?
Are we referring to the other, like the 2-axle trailer
Well,
that's on the lands, or the dwelling?
so which are we referring, so,
So there is a dwelling and a detached garage, which is on another portion of the lands.
okay,
And then there's another 2-axle style trailer that is fairly close, actually, I would say, to this trailer, but I've been advised by the applicant that it's going to be removed or demolished.
okay, so it's the other
It is
house
the
that
other one
I
that's
can't
existing.
see, or, okay,
Right.
all right, thank you, thank you. Thank you.
Yeah, I can speak to the garden suite definition a bit more specifically. So Planning Act does provide a definition. Garden suite means a 1-unit detached residential structure containing bathroom and kitchen facilities that is ancillary or accessory or subordinate to an existing residential structure, and that is designed to be portable.
Thank you. Is there any other questions, comments, concerns from council?
I'm just,
Councillor Thompson?
yes, thank you. I'm just curious, it's designed to be, so it just has to have a bathroom and a kitchen and designed to be portable. What's the difference between that and a trailer?
Typically, it'll have the running gear removed in most cases, but the idea is that it needs to be able to be removed after the expiry of the bylaw. So once you hit, if you're going to allow it for the full 20 years, once you hit 20 years, it's got to be able to be removed. So it cannot be permanently affixed to the ground.
A regular trailer would have a septic that's attached to it, that's in it. You drive away with it. With a garden home, the septic would be in the ground, and your water, you'd have a separate well. But in a trailer, you would have a tank on it. I believe that's the difference.
Thank you, that makes a big difference.
Okay.
Thank you. Is there any other questions, concerns from council at this time? No? I thank you for your time, gentlemen.
Thank you for your time.
At this time, I'll ask staff to please describe the purpose and effect of proposed zoning bylaw amendment related to file number ZB 2306.4 submitted by JP2G Consultants, Inc. on behalf of Track Corp Canada, Inc., and summarize the written comments received.
Thank you. I won't dive into this one too much because I believe the applicants have a bit of a presentation. So this application's in respect to the lands presently known as 462 Wilson Farm Road, which is located and part of Lot 13 and 14, Concession 8, Geographic Township of Bagot, which essentially is the home of the Calabogie Motorsports Park. The purpose and effect of the proposed zoning bylaw amendment is to rezone the severed lands from Tourism Commercial Exception 16 holding to Rural Exception 53 as a condition of consent applications having county file numbers B1123, B1223, and B1323 to permit the residential uses permitted in the rural zone. Additional provisions will include an automotive storage garage accessory to the residential use, which can be constructed before a dwelling on subject lands. The automotive storage garage would have a minimum permitted height of 5 meters with a maximum permitted height of 10.5 meters. Additionally, a secondary dwelling unit would be permitted to be larger than that of the primary dwelling with a maximum of 10.5 meters. And as of today, we have not received any written comments on the application. Thank you.
Thank you very much. Does the applicant or the representative wish to speak in regards to the application? Thank you. If you could just introduce yourself and
I can answer questions.
Sorry, Jack, we know you're back there. Yes, you can sit there if you want.
Talk.
I might just debating whether to work with one or two easels here. Yeah, I think I'll just try one. Oop.
That'll cost you.
That wasn't great.
You can sit down. Thank you, Mayor Weir, members of council, staff. It's been about 9 or 10 months since I've been here. I think
I'm just going to ask you for the YouTube people just to identify yourself.
Oh, absolutely. My name is Brian Whitehead. I'm the operations manager of the Pembroke office of JP2G Consultants. I'm also a planner, and I'm here representing Track Corp, that operates as Calabogie Motorsports, and I'm joined behind me by Mark Steenbackers, who's the general manager, top head guy, and as his father, who's Mr. Steenbackers, because I can't remember his first name. My apologies. Jack. So we're here to provide council with a brief explanation of the purpose and effect of this application for zoning bylaw amendment. I just wanted to give a little bit of background first, and then I brought some plans to help illustrate how the zoning will be implemented. We're hoping to implement the zoning through these drawings. When I was here last time, I think it was January this year, it was regarding an official plan amendment number 37, and that amendment was to redesignate the property to allow rural uses, including low-density residential, and there's a variety of rural type of uses like anywhere else in the township that are now permitted. And that application, and because the consent process takes a long time, we filed the severance applications, the 3 severance applications for the 3 proposed lots here on Wilson Farm Road, before that official plan amendment was approved. So it was subsequently approved, and now it's in effect. And also because the process is slow for the consents, Mr. Steenbacker instructed us to sort of file the zoning application. We knew it would need a zoning application, and we had written a planning report in support of the land severance application. And there was also a detailed noise impact assessment carried out for the property. And really, it's the noise impact assessment that is driving many of the zone changes and conditions that would be implemented through a development agreement. And there's also been a number of other studies done on the Calabogie Motorsports property, like archaeology's been done for the whole site, wetland evaluations, hydrogeology, you name it. There's been every kind of study you can imagine. But we had agreed to do a site-specific noise assessment for this particular land severance application. So really the purpose of this zoning is to implement the recommendations of the noise study, which would refer to minimum building height, for example, of, well, maybe before I get to there, I'll just explain. It's to implement the recommendations of the noise study, but also there's policies on the Calabogie Motorsports property that have to be addressed as part of any new development proposal. And that would include lot grading and drainage, and separation, just 30-meter setbacks from any wetlands. So this is the grading plan. So we knew that the land severance hasn't actually been granted yet, and it's pending. So when we filed the application for zoning, in our request, we requested that council not make a decision on the bylaw until after the land severances were granted. And that's purposeful because we don't want council to approve the bylaw, and then the county issue a condition with conditions that require different zoning. And coincidentally, and the bylaws application we filed has been processed. We're at the public meeting. Coincidentally, we received the planning report on the land severances yesterday. So, and of course, it does have recommendations in the planning report that are different than what we applied for, and they're also different from what we discussed with staff as part of a pre-consultation discussion for this zoning application. So we filed a zoning application, we reviewed it with your staff. The public meeting tonight, the notice is based on the discussions we had with staff, which included a rural zoning, and the county's coming back with another recommendation on how to implement the recommendations of the noise study through zoning and the development agreement, which are very different than what we had anticipated when we filed the zoning application. So we have a meeting scheduled for next Monday with Township staff and the county to work out some of the details on the zoning. So it's a good thing that it's not on the agenda. There's no in fact, there's no bylaw. So everything I'm presenting to you tonight is for information purposes, and there'll be another report that comes back to you at a later date once all the planners discuss it and come back with a recommendation for you. But long and the short of it, I think we're in agreement with all of the recommendations of the noise study. It's all about how they get implemented that we have to sort out. So I'll just give you a quick rundown of the property and how these recommendations will roll out. Well, you won't be able to see the key map, but does everybody generally know where Calabogie Motorsports is and Wilson Farm Road? Okay, so this is Wilson Farm Road, and there's 3 lots. The smallest lot is just over 1 hectare in area, and they get larger. So I don't know the exact areas, but this one's probably about 3 hectares or 7 acres, 5 acres and 2.5 acres. So they're large lots, but there is a wetland at the rear of the property, which reduces the size of the building envelope. And in the policies that apply to all of Calabogie Motorsports, there's an automatic 30-meter setback from the wetland. And that setback has been surveyed in the field. It's been actually staked in the field by a qualified biologist and picked up on a survey plan by Adam Kasperzak Surveying. And that data has been forwarded to the engineer that prepared this this lot grading and drainage plan. And it's O'Connor, Adam O'Connor is an engineer that's been working with Mark for a long time, qualified engineer. So this is a grading plan that shows where the wetland setback would be. This will be an environmental protection zone, and Eric's preference is that the 30-meter setback be in an environmental protection zone too. It doesn't mean you can't walk on it, or anything like that, but you're not supposed to alter it in any way, or it gets kept in a natural vegetated state. And this is a lot grading and drainage plan, so it shows contour information that's been surveyed by Adam Kasperzak. It shows location relative to the road, entrances, driveways, buildings, the dwelling, septic system, well, and the garages. So I've highlighted the dwellings in yellow and the garages in red, and the wetland in green. So this is standard. This is the location of these buildings and structures is not necessarily how they'll get built, but it is indicating on this plan that how the sites are suitable for the development of those uses, and that they'll fit and they can be developed. So this plan will form part of an agreement that gets registered on the title, and the property has to be developed generally in accordance with the requirements of this plan. So I haven't talked about the noise assessment yet, but keep in mind that these garages are approximately, well, not approximately, exactly 10 meters deep this way and 30 meters this way. So 30 feet by 100 feet. So this, maybe I should show it this way. This is the same angle as the previous plan. Certainly. How's that? So the tracks over here, this shows the lots a little better. It shows the garages in white, and it's got dwellings and garages on each site. So this is figure 7 of the noise study that relates to the recommendations of the noise assessment. And when we were doing the noise study, like noise attenuation, is based on buffering, using buffering as a means of mitigating the potential impacts of noise and reducing them to an acceptable level, and having an area on each lot that would be suitable or within, like there'd be some noise, but it would be within acceptable guidelines. So that the types of recommendations that we're looking at would be how the dwellings would get constructed, air conditioning, types of windows, types of insulation, types of the windows themselves, like there's the building aspects of the dwellings. Then there's the a notice on title, for example, notifying future purchasers about the impacts of potential elevated noise. There's some, but the key feature on this, and we figured this out sort of partway through, because rather than having to build a large berm, which could be expensive, and having a fence on top of it, it was concluded that the garages could actually be the noise attenuation feature for these. And that's why we showed the garages on the last drawing where it's being 10 meters by 30 meters. So when the noise study is done, it's done based on a conceptual model, and it's a modeling exercise, as many engineering studies are. And so it makes assumptions about noise sources, and there's actual data that they have from Calabogie Motorsports on noise that this SS Wilson, the noise consultant, has been able to use. So it's actual data, and they model it in terms of how far it is away and what types of features are in between that can attenuate the noise, and come up with recommendations for the types of mitigation measures, including the garage. And one thing I want to point out is that these garages are based on a typical garage size. So roughly, that's not to scale, but a typical garage might be 10 meters by 10 meters, which is like 32 feet by 30 feet, sort of square, for two bays and a door. And that would be a typical garage. But what we're anticipating is that these garages will not be typical garages. They'll be garages used by people that would want to use the track. So, and they would also be used for noise attenuation. But one of the recommendations is for the first lot that, in fact, maybe I'll review it with you just so I get it right. Just bear with me. For lot 1, a 5-meter high barrier berm combination is required to protect the outdoor point of reception. So out here, the berm and barrier shall extend from the east side of the garage building 20 meters in an east direction. The barrier alignment and the extent of the barrier is shown in figure 7, which is here. This is figure 7. So it's showing a 20-meter extension of either a barrier, like a berm with a fence on top. But what this report also says is that garages are an acceptable form of mitigation. So after some discussion, our client had some concerns with this recommendation for the berm because it didn't really provide the flexibility that he needed. Because what if somebody wants to build a bigger garage? That bigger garage could be used for a berm or for attenuation in lieu of a berm with a fence on it. So there was another clause added to the recommendations, but not at the front, but at the back. So there's conclusions and recommendations at the front, conclusions and recommendations at the back. And the one recommendation at the back reads that the use of a supplementary berm and or sound barrier wall on the top of one of the two ends of the proposed garage, as well as required to be determined at the building permit stage, whereby the final alignment of the garage and the orientation of the dwelling structures will be prepared for the building permit purposes. What that really means is when the people come and they buy a lot and they want to put up a garage, we don't know how big a garage that they want to put up on lot 1. So it might be, if it's a 10 by 10 meter garage, then they got to put up a berm. But if it's a 10 meter wide by 30 meter garage, that 20 meters that would be berm will be garage. And that's the way we've shown it on this plan here. Okay. So the other piece that's important is that a 10 by 30 garage is a large garage. I mean, we're talking probably $500,000 to build a garage that big. So some of the inquiries that Mark has had about buying this lot are that, well, and some of the others for that matter, if I want to build a big garage and spend $500,000, I don't necessarily want to build a house at the same time. So what the bylaw proposes is that an accessory use, well, firstly, the bylaw would allow the garage to be built first, and it would include a provision allowing an accessory dwelling to be included inside the garage, rather than, and then it would also permit a dwelling, but that would be at a later date. So really, what we're looking at is some flexibility on how the development of these lots can roll out based on the nature of the lots, the location relative to Calabogie Motorsports, and the purpose for which they're going to be used. So that really is the essence of it. Now, the garages themselves have to be built 5 meters high minimum, which is, I don't think, a problem. And there's a maximum of 10.5 meters. I don't think that'll be a problem. But the whole point of pointing this out is that what we're really looking for in the zoning and in the development agreement is some flexibility. So things like the building height of the garage would be in the zoning. There's a minimum of a 15-meter garage width required, which is fine. That's in the zoning. Those types of provisions under zoning that are typically required, what the county is suggesting is that all of the conditions, or not all of them, but the majority of them, including the one for lot 1, where there's a requirement for a 20-meter berm and fence, be required. But that if we include it in the zoning, then the problem with that is that it's enshrined in the zoning, and if somebody wants to build a 30-meter wide garage, they still have to put a 20-meter berm on it. So it doesn't give that flexibility. So what we're looking for is that certain things to get the flexibility, be included in a development agreement with the municipality, like a decision to, well, like I read in the second, the need for a supplementary berm be determined at the building permit stage, depending on the size of the garage. Common sense, that's all. And so really, that's the nature of so essentially there's things we want to include in the zoning, and there's things we want to include in the agreement, And mostly the terms that we want to include in the agreement are the ones that can be worked out at the building permit stage when the owner comes in and says, this is the size of the garage I want for lot 1, and how much of a berm will be needed will be dependent on the recommendations of the noise study. They'll be in the agreement. That's all.
Thank you.
I hope that was making sense, yeah.
Thank you. Does anyone else wish to speak in favor of the amendment? None seen at this time. Does anyone wish to speak in opposition of the amendment? None seen at this time. Are there any questions from council? Councillor Thompson?
I thank you for that presentation. It made complete sense. This is a very unique kind of situation where you can't build until you guarantee the noise attenuation, right?
Right.
So we do need some flexibility. What I'm wondering is when you say what is going to be on the deed? So we have to have some flexibility. We want to make sure we have that within the building permit process. So my question is really for staff, what are the mechanisms to allow us to do that? Because usually we've got building standards and they're building standards. Like where do we get these guarantees? More a process question.
Right, yeah, thank you, and through the chair. So when it comes to applicable law, both the development agreement and zoning are applicable law, and what that means is that a building permit can't be issued in contravention of them. So when it comes to, if you know, just some added flexibility, I think to Brian's point, what he's saying is that, you want to be able to still meet the intent, or perhaps have an addendum, to the noise study prepared if the physical layout of the lots is going to be somehow different than it's conceived today. And I think that's a fair point. Whether it's through zoning or through the development agreement, I think you can introduce the potential for reconfiguring the lot. I think in principle you need noise attenuation. It's being proposed today through a combination of berms and garages. If someone just wants to build a giant noise wall, I'm sure that there are other ways to attenuate sound on a property that could be considered. So I think you just introduce that, and we'll work with Brian and the county on the exact language, just for the record and for the purposes of this public meeting. It's not my opinion that adding provisions, additional provisions specific to a noise study in order to implement the conditions of consent. I don't think that changes the purpose and intent of this amendment. I wouldn't consider that another public meeting, for example, would be necessary in order to make those changes. I think those are reasonable in order to implement the development that's contemplated here. I don't know if that helps. Thanks.
I'm not sure either. So basically, we do have the ability to make sure that things happen the way we plan. It's not something that's going to end up in the planner's office and they forget or they miss it. Like, how do we make sure? You probably know more about this than I do.
If I may?
Okay. Yes, go ahead. Thank you.
Yeah, just to add to what Eric's saying, I think we're all in agreement with what needs to be done. It's how it gets done in order to get the flexibility that Mark is looking for, or Calabogie Motorsports is looking for. But if it's any comfort, both the agreement, development agreement, and the zoning are acceptable forms of implementation that the agreement binds the owners. The agreement would be with Calabogie Motorsport because they're the existing owner, but they would be, future owners would be bound by the terms of that agreement. So it runs with the title. And the zoning, of course, is in your bylaw, and it's applicable law as well.
Thank you. Is there any other questions from council? None seen. I thank you all for your time. Thank you. This therefore completes the public meeting process. Council will give careful consideration to the comments received by the applicants before it. If there are no other questions, comments, concerned by council or staff, if there are no further comments, questions, I then declare this public meeting closed, and it is 3:44 p.m. Thank you all for coming out. Thank you for your attendance.